This is the Data Privacy Detective. Well, it's February 2024. We're looking back at the month of January 2024. And with me are my regular good friends in the data privacy space, Brion St. Amour and Yugo Nagashima. Brion, thanks for joining us.
Glad to be here, Joe.
And Yugo, as always, thank you very much. Oregato.
Thank you so much. Do itashimashite.
And Yugo and Brion are both terrific data privacy and other expert attorneys at the law firm of Frost Brown Todd. The data privacy detective is no longer with any law firm. I'm on my own as an old guy and having fun. But let's jump into this, Yugo. It seems that the year started with a rather interesting, exciting case where privacy is butting right up against the U.S. Constitution. What happened?
Yes, so we're at a very interesting time, and Patreon, video content monetization platform, something akin to YouTube, has moved forward. So they've been sued, and they moved for a motion to strike down the Video Privacy Protection Act, arguing that the law violates the First Amendment by restricting speech.
The video, that's the VPPA. We've all got to learn these new acronyms. No, wait a minute now. What is the VPPA, and what does it regulate?
The VPPA sounds like the CCPA, but it's much, much older. It's from way back in 1988. And
wait a minute. Yeah, I guess there were computers, but there wasn't much of an internet. But go ahead.
Right. So that's why hence the word video, right? It restricts businesses from sharing information about a customer's video rental and purchases. And I want to give you a little more context. Why would we have such a law in the books, right? So VPPA was passed by Congress after a scandal involving the Washington Post article, I believe it's the Washington Post, or an article disclosing the then conservative Supreme Court nominee Robert Bork's video rental history from one of his local go-to rental video shop.
Aha, and of course he did not get confirmed, probably not just for this reason, of course. But well, now wait a minute. We're dealing with an old video law, relatively old. In 2024, what's going on here?
With the modern day of privacy and with litigation, there has been a number of class action lawsuits targeting video content creation platforms, right? Places where you can stream video, alleging content platforms such as Patreon. It violated the VPPA by sharing the viewed content history of its users with Facebook through the metapixel. Without user written consent. So what the class action plaintiffs are claiming essentially is that by having a metapixel on a page that has a Patreon or YouTube video, it allows the third party Meta to basically access what video content was viewed on these content platforms, the defendant's website. So hence the video viewing history has been made public, so they should be punished because they're not following the law to get consent.
Well, of course, first up is to see what are the terms of use and so on. But here are the plaintiffs are arguing what? The First Amendment?
They are. That's the latest move. In their motion, Patreon has noted that the BPPA's purpose was to silence speech, and therefore it violates the First Amendment. That's the major argument.
How does it silence speech?
Very good point. So what they're saying is there's a couple of things. The first, they looked at the legislative history and noted that the BPPA was enacted for the express purpose of silencing disclosures about political figures and their video watching, not for reasons to protect the average video viewers. As I noted earlier, right? I may have gone off script, but it's actually related. It was a reaction to the Washington Post basically getting the information from the video store about then nominee Robert Bork. So that's the first part. The second part that Patreon notes is that the BPPA does not really protect the consumer's privacy because it only restricts businesses from disclosing the titles of these video content, right? But it does not restrict the disclosure of other information, such as the video subject matter, or who the performer is, or what the content is, or what the political slant of the video is, or the violence of the nature or pornographic nature, or any other thing that may be more relevant to the detail of the content of the video themselves. And third, a Patreon attacks, and I think this is very interesting, they attack the the presumption of the damages, right, which is $2,500 per violation for the consent requirement. And what Patreon says is, that's arbitrary and onerous. That's way too high for just disclosing the name of the video content that someone viewed without consent.
Okay, well, that's Patreon's argument largely. And what are the class action users saying?
So not just the users, but there's also amicus briefs. So those are the friends of the court. They're not actually the plaintiffs. But there's a lot of support for the plaintiffs. And what they're saying is the content creation platforms could have easily obtained written consent via a pop-up box or some show before the video is shown, but they haven't done that. Amicus briefs also say that the BPPA does serve a privacy purpose because it guards against unknown or non-consensual disclosure of people's viewing habits. I mean, even though it may not protect the deeper content or the performer and other items, it's still protecting the title, and the title can give you a lot of things. And if those items can be shared without consent, it's not really protecting privacy. And in fact, the government also is taking a very similar position, putting in an amicus brief.
Very, very interesting. Well, let's turn to you, Brion. And really, in a way, it's an easy transition here. Of course, we don't have an overarching federal U.S. data privacy code the way the EU does and some other countries do. And so we've been watching the state laws. And January 2024, there are 2 states whose names begin with new that are in the picture here. What's the news?
Early in, I guess mid-January, so on the 18th, New Hampshire passed its comprehensive privacy legislation, and the state of New Jersey passed theirs just a few days earlier, and it was signed and went into effect on the 16th of January. And those are kind of the 2 newest states joining our state-by-state approach. The New Jersey law is set to take effect 1 year, so both laws actually will take in effect in January of 2025.
And both target consumers, am I right? But who falls into that category?
Yeah, I mean, as we go through this process, in looking at, and this is one of the challenges with the state-by-state approach, is you do have to look at who is considered a consumer, and really becomes a fundamental issue in these state laws. And so luckily in both New Jersey and New Hampshire, the consumer are really residents not acting in a commercial or an employment context. So this means the personal data, which is kind of very specific, it has to be reasonably linked to the consumer as well. And so both of these states kind of exclude all of the other, especially the federal, like HIPAA and some of the other considerations that kind of would push them into potentially some level of preemption.
Interesting. Yugo, you had a question, I know.
Yes. So Brion, so then what is the focus of the laws? And with other states, we've seen like the minimum thresholds of how many unique consumers information that you have to collect. Is there a similar threshold?
Yes. So, kind of twofold. There's kind of 2 pieces of that answer. So let's look first at New Jersey. And the first there is it's related to a controller. So that business that's conducting business in the state, and they're processing data for at least 100,000 consumers or 25,000 consumers if they're deriving revenue from that personal data sales. Where New Hampshire law is slightly broader, and it relates to processing data, but it's related to 35,000 or 10,000, depending on, and in both cases, unique consumers. But if the 10,000 threshold is if you're deriving more than 25% of their gross revenue from those data sales. And so in these cases, the controllers or the processors have to rely on responding to consumer requests within 45 days. And in both cases, they have a mandate that requires that. In both, New Jersey will be active July 2025. You have to be able to comply, where New Hampshire requires implementation at the launch of the law. So there's a little bit of a delay in New Jersey to give you some time to build out processing obligations to handle those requests of opting out. So there is a uniform opt-out mechanism that both are going to require. And then, ultimately, these laws really just emphasize the importance of protecting sensitive data. And then they outline, like almost every other state, all of the specific processing rules there.
Yeah. How about enforcement, Brion? I mean, can an individual sue, or what happens?
Yeah, and I guess luckily, depending on if you're on the corporation side or the individual side, we may not be quite so lucky. But in this case, New Jersey and New Hampshire join what is becoming more of a standard trend of requiring the state's attorney generals to enforce. And so there's no private right of action in either the New Jersey or the New Hampshire law, which keeps California as the lone comprehensive privacy law that allows for a private right of action.
Interesting. Well, it does sound like these two laws are similar to many of the other states that have enacted things. And where are we? I mean, we've got 50 states. Are we getting close to halfway there, or where are we?
Well, and as we discussed a couple months ago, the federal government is slowly toying with some comprehensive tech privacy laws. But right now, that state-by-state approach is kind of pushed us into 13 states with laws passed. And there's 2 more that have laws far enough down the process that I feel fairly confident they're going to be enacted this year in 2024. So by the end of this year, it looks like we'll have over half the country with some form of a state-level comprehensive privacy protections in place for the residents of their state.
Yeah, I think you said there were 2 more. I think you meant 12 more states are pretty close to having something adopted, which would bring us to 25. Yeah. So we're halfway there, and maybe that's at the point where Congress says, look, we better get this together. We are one country after all. We'll see what happens. Yeah. Well, thank you, Brion. And here's the third topic. Well, we're going to talk about apps and app stores. Now, a lot of people assume that the App Store means the Apple App Store. But an App Store and the Apple App Store are not one and the same. The Apple App Store, according to Investopedia, is a digital distribution platform where individuals can buy and download digital software and applications. Apps are an abbreviation for applications, software tools that provide functionality to an operating system. Now, when one of us acquires an app through the Apple App Store, the app is stored in the iCloud, Apple's cloud, an Apple service, so that we have easy access from any signed-in device, at least those that use an Apple operating system, an iOS. Well, Apple claims a trademark on App Store, but there are other app stores, such as Google Play, Amazon App Store, BlackBerry World, remember the BlackBerry, or Microsoft Windows Store. Apple's App Store website says that privacy and security are built into everything that Apple does. Well, with that background, let's consider 2 events in January 2024 that are very important to global data privacy. Now, first, a little background about Apple and the European Union. Given Apple's dominant share of App Store downloads, Apple has more than once made changes to conform to EU concerns. 6 years after its launch in 2008, Apple's App Store changed the word free when we download an app to get when we download an app. Well, that's because Apple makes a lot of money through its App Store, though users don't recognize it when they download an app. Instead, app developers who sign up with the Apple App Store pay Apple an annual $99 fee plus 30% of the revenues they receive to Apple. Well, that's generated hundreds of billions of dollars of revenues for Apple over 15 years. The Apple App Store serves the iOS market. Google Play serves the Android world. It used to be called Android Market, after all, for Android mobile apps. Google charges only a one-time $25 fee to enroll as an App Store developer. And there's no more due to developers that charge nothing to users, but 30% of app revenue if it earns money. But Google Play apps are free rather than paid services generally. Well, on January 25th, Apple announced that it's changing how it's going to operate in the EU in order to respect the EU's Digital Markets Act, which will take effect on March 7, 2024. This EU-wide law aims to ensure fair and open digital markets. It's a centerpiece of the European digital strategy, including avoiding the abuse of market power and encouraging new entrants to get into the tech field. Well, Apple announced that it's loosening its App Store rules for the EU. It will now allow iPhone and iPad users to use alternative app stores to download apps, such as games and productivity tools. Financial institutions will be able in the EU to offer within the Apple App Store system methods of payment within their apps. iPhone users will be able to download alternative browsers such as Google Chrome or Firefox. Well, Apple coupled these changes with a warning about the impact this will have on privacy and cybersecurity. It said that it will continue to oversee, for data privacy purposes, apps and app stores that are beyond its own app store. But Apple predicted that hackers and cyber criminals are going to have a new pathway to distribute malware and steal identities and money. EU developers will pay to distribute their apps 50 euros per download only when an app has been downloaded 1 million times or more within a year. And existing developers can continue existing terms, or they can pay a lower 17% commission rate to Apple. Now, these are big changes. A New York Times report had one games developer calling Apple's new policies a, quote, horror show, close quote. So we'll learn soon how the European market reacts to Apple's changes. The European Commission, the EU Commission, had no immediate comment, and we'll have to watch for how the EU Commission decides whether Apple's changes meet the Digital Markets Act's requirements. Well, how about the United States? Apple has not promised to do in the USA what it is doing in the EU. Now, a New York Times report on January 27 revealed what happened to Beeper, a San Francisco music company. Beeper Mini launched as an app in December 2023. Now, this is an app that lets Android phone users send encrypted messages to iPhones. And 100,000 people promptly signed up for the new app. Well, Apple responded by blocking Android users from accessing Apple's messaging device. Well, Beeper responded to that by encouraging its customers to use Mac computers, Apple's computers, to connect so they could keep getting messages and use the Beeper system. Apple then responded to that by reportedly blocking users from access to Apple's messaging service on Mac computers. And Apple's basis, although it wasn't reported as of the end of January, was that it does not want customers to use Apple services in a way that is deficient in data privacy or is cyber insecure. Well, we'll see how the U.S. Justice Department and the FTC respond from an antitrust and a fair trade standpoint if this is a sustained practice of Apple in the USA. So the battle of tech giants rolls on. What's our January lessons from these two things? Well, I think it's the data privacy and free market competition purposes can clash. And the tech giants can use data privacy and cybersecurity as a weapon to argue that they should be forgiven if they're being tough about protecting data privacy for users, even if they're enormous tech giants. This battle is waged below the surface for most of us, but it's going to help drive how data privacy is balanced against the interest of robust tech competition. Yugo, any thoughts?
We've been seeing a couple of cases even in the United States with Epic Games challenging Apple and Google. And do you feel that those cases where the Google Play Store and the Apple App Store has been challenged would influence whether that has influenced Apple's behavior in Europe?
Well, I think Europe's ahead of the United States in the data privacy field. I think we'd all agree on that. Whether it's ahead or behind anyway, it's more privacy-centric and it's comprehensive, unlike the U.S., which doesn't have a code, as we've talked about with Brion. So I don't see that having any impact on the EU. The more interesting question is, why would Apple do something in the EU that it then says it shouldn't have to do in the United States? And I doubt it'll be enough just to say, well, privacy is the reason we do it. But we'll have to see how the FTC responds. We'll have to see how the competition among app stores, there is competition, unfolds. But what you see here is no one way, privacy and commercial competition laws have different purposes. And as in this case, they can clash and have to be resolved. Well, thank you, Brion and Yugo, for joining us. We'll cover these and other issues again in another month. That's it for January. And as always, I will remind our listeners, protecting your personal privacy begins with you.